State of New Jersey versus William Ortiz, State Indictment 17-09166. Appearances, please.
Good afternoon, Your Honor. Cynthia Robinson, Deputy Attorney General of the State.
Good afternoon, Your Honor. Joshua Allman, dedicated and all on behalf of William Ortiz, my wife and large family, and a cadre of supporters in the gallery.
Good afternoon to all. Mr. Altman, you presented the court with a confidential, I don't know if it's a DVD or a compact disc.
I think a DVD.
A DVD.
Or a CD, we'll call it a CD.
A CD, how's that? For Mr. Ortiz, reflecting his medical status. That will be attached to the JOC. You're free to follow up if somehow it gets lost in transition, which happens.
Sure.
Please get a hold of me, and we'll make sure that those records are provided to the Department of Corrections. Does your client stand by his plea?
He does, Your Honor.
Any additions, corrections, or modifications to the pre-sentence investigative report?
Other than when I provided to the court, no.
Mr. Prosecutor,
No, Your Honor.
I have reviewed the pre-sentence investigative report. I note that Mr. Ortiz has no prior criminal history in any regard. And as a result, I find the application of a sole aggravating factor, and that is 9, the need for specific and general deterrence. Specific deterrence as to Mr. Ortiz. Mr. Ortiz was put in a position of trust, and indisputably he abused that trust. And a message has to be transmitted, regrettably, both to him and any other public officials, that when one abuses the public trust for financial gain, there is a rather severe punishment. Any objection to aggravating factor 9?
I will submit, Your Honor.
No, Your Honor.
As it relates to mitigating factors, in light of his lack of criminal history, without question, mitigating factor 7 applies. Any additional mitigating factors?
Your Honor, I did submit a sentencing memorandum.
Yep.
Where I cited 8, 9, 11, and certainly 12, and a non-statutory mitigating factor. I know 10 can't really apply, but based upon the length of this case, I would ask the court take into consideration Mr. Ortiz's appearances in court, which apparently doesn't always happen in front of Your Honor. His
Well, when it doesn't happen, people are brought in on a bench warrant.
Exactly. So that he's been cooperative with the entire process over the 3 years, and I would ask that that also be taken into consideration. So ultimately,
Excuse me, Mr. Owen, hasn't he gotten the benefit of that cooperation? If he failed to cooperate, the state would move to vacate the plea.
he has, Your Honor.
Yeah, so the fact that he's been compliant and cooperative is what is expected of him, right?
True.
Yeah, okay.
So I would submit, as you said, 7, 8, 9, 11, and 12, Judge.
Well, certainly 12 applies without question, and I don't believe there's an objection from the state on that.
Of course not, Your Honor.
As to 8, the defendant's conduct is the result of circumstances unlikely to recur. What is the position of the state?
Your Honor, given our discussions with Mr. Ortiz during the course of this investigation, we believe that that is an appropriate mitigating factor.
And 9, the character and attitude indicates he's unlikely to commit another offense.
The state would also agree with that assessment, Your Honor.
And I agree with the state and the defense on that. We have an individual who's well in his 50s, has no criminal history, has otherwise been a contributing, valued member of society. That is in no way to minimize the seriousness of this offense. Having stated that, I do find the application of mitigating factors 8 and 9. We have a gentleman with no prior criminal history who's fully satisfied the terms and conditions of the plea, which, as Mr. Altman has noted, has been for a protracted period of time. So I do find mitigating factors 8 and 9, and of course 12. With regard to mitigating factor 11, the argument of an excessive hardship, I'm not going to apply that. Undoubtedly, Mr. Ortiz and the sentence to be imposed by the court will impose a hardship on his loved ones. That is tragically the collateral consequence of his committing the serious criminal offense which brings him before the court. This is a sad reality of sentencing individuals to periods of incarceration. Not only is Mr. Ortiz required to suffer for his own offenses, but those who care about him the most as well. And so I view this undoubtedly as an emotional hardship, without question, but I don't view this as an excessive hardship.
If I may, Your Honor, that was cited in addition, because that happens to just about every defendant. But it was cited that in conjunction with his medical history. I had previously submitted a letter, and certainly it's expected that the Department of Corrections will be able to accommodate him in any of his conditions, but I cited it in the sense that his time might be harder than the average healthy inmate. So that's why I cited it. Maybe it doesn't rise to the level of excessive, but I think it was my obligation to at least raise that mitigating factor.
I think you're doing your job. I just don't believe it rises to the level to implicate the statutory mitigating factor. So I will find aggravating factor 9. I will find mitigating factors 8, 9, and 12 with particular weight to mitigating factor 12. There was an application by the state under 2C:43-6.5F. That motion was well founded. I'm going to grant the application. Mr. Altman, I'll hear you on sentencing.
Judge, I submitted a sentencing memorandum which adequately characterizes my position. So I will submit to the court only to mention that you also found 7. In your
Yes,
citing of the,
I'm sorry, yes. 7, I'm sorry, aggravating factor 9, mitigating factors 7, 8, 9, and 12.
yes.
With particular weight to mitigating factor 12. I'm sorry, go ahead, sir.
I will submit to the court's discretion, Your Honor.
Counsel for the state.
We only ask that Your Honor enforce the plea agreement.
Mr. Ortiz, is there anything you'd like to say?
No.
Has the document forfeiting public office already been effectuated?
Judge, statutorily, the office is forfeit when the plea is taken.
Yeah.
We often have an order that follows up, and the state is happy to submit that to Your Honor, but by statute, it is forfeit at time of conviction.
Very well. Mr. Ortiz, consistent with the plea and noting mitigating factor 12, I'm going to send you and remand you to the Department of Corrections for a period of 5 years with a period of 1 year of parole ineligibility. You will have to forfeit and will never be able to apply for public office in the state of New Jersey again. I'm going to award you 1 day of jail credit. I'm going to award the following mandatory fines and penalties: a $50 VCCB, a $75 safe neighborhood fine, and a $30 police fund. I'm also dismissing counts 1, 3, and 4 of indictment 17-09166. Has there been an executed appellate rights form, Mr. Altman?
There is, Your Honor.
Very well. I'm going to make that a part of the court record. Thank you, sir. In summary, Mr. Ortiz, you understand that you have the right to appeal. I note that the court had sentenced you consistent with your own plea agreement. Notwithstanding, you've got 45 days to file a notice of appeal. You're entitled to a 30-day extension of time, subject to the approval of the appellate division. If you can't afford a lawyer for purposes of appeal, the public defender's office will represent you. And you've got 5 years from today's date for a petition for post-conviction relief. Have you understood everything? Any questions of me? Are you satisfied with the legal representation you received? I would expect so, Mr. Ortiz. I wish you well, sir.
Thank you. Judge, just administratively, I called up the Union County Jail yesterday. Mr. Ortiz has a number of medications. I and Mr. Ortiz's wife are going to bring those over at their suggestion. And I don't know if a heads up needs to be given to the jail that he's coming over. They're not just going to accept medications without him physically being there. But I don't know.
Sheriff, do we know how we do this?
Pretty much what we do is we just transport them. All I can do is just give a phone call. And
If you remind, are you sticking around?
Sure.
I'll call the lieutenant over there and I will advise them in your presence. Any objection to me doing that?
Of course not, Your Honor.
Thank you, Your Honor.
Yeah. We'll do that immediately after Mr. Debonis.
Thank you, Your Honor.
You're welcome, sir. On the record, please. State of New Jersey versus Joseph Debonis. State indictment number 17-09166. Appearance, please.
Good afternoon, Your Honor. Anthony Robbins, Deputy Attorney General for the state.
Good afternoon, Your Honor. Stephen J. Coliani from the Law Office of S. Carl on behalf of Mr. Debonis, Your Honor. Just a housekeeping matter before we begin because it is so primary. Mr. Debonis as well has medication. He has diabetes. I have the medication here. It doesn't seem like he would be able to be transported with it. So if I could accompany Mr. Altman and yourself and
Yeah.
a phone call.
Any objection to that?
Of course not.
Very well. Counsel, does your client stand by his plea?
Yes, he does, Your Honor.
Any additions, corrections, or modifications to the pre-sentence investigation report?
None, Your Honor.
Mr. Prosecutor?
Done, Your Honor.
Very well. I have reviewed Mr. Debonis' criminal history and the like. I'm inclined to find aggravating factors 3 and 9. With regard to aggravating factor 3, the risk of recidivism, it appears that Mr. Debonis, although dated, previously used marijuana and cocaine and routinely used alcohol through and including March of 2018. The need for specific and general deterrence under aggravating factor 9 certainly appears self-evident to the court. Any objections to 3 and 9?
No objections, Your Honor.
Very well. Does the state seek any additional aggravating factors?
No, Your Honor.
As it relates to mitigating factors, consistent with Mr. Ortiz, the court is inclined to find mitigating factor 12 and give it great weight. Any additional mitigating factors for Mr. Debonis?
I would just note mitigating factor number 7, Your Honor.
I can't find mitigating factor number 7 with Mr. Debonis because I believe he's got a prior criminal history in New York. Correct? 2 convictions.
Yes, Your Honor. I would just cite 7 on behalf of the fact, Your Honor, that those were approximately 20 years ago.
Well, my reading of the statute does not have a time limit. This is in Rule 609 for trial purposes. However, I agree that it is dated. However, he was first put on probation in 1994, and which means it would have expired in or around 1999 when he committed a second-degree offense, was incarcerated for 3 months, and then placed on probation again through mid-2002. I'm going to give aggravating factor. I'm not applying that mitigating factor. I'm not going to apply an aggravating factor because I do not find that he had an extensive prior criminal history. And in light of the datingness, I would agree that aggravating factor 6 doesn't apply, but I cannot in good conscience in light of his record find mitigating factor 7. Though I do note that he's lived a otherwise law-abiding life with the exception of this very serious transgression for 13 years, something like that.
I understand, Your Honor.
Yep. I'll hear you, counsel.
Your Honor, this is a negotiated plea between the state and Mr. Debonis. I would just ask that Your Honor honor the agreement. And again, Your Honor, I would note that, as Your Honor just indicated, Mr. Debonis has otherwise for the past 13 years led a law-abiding life.
Before I hear from the state moved pursuant to 2C:43-6.5F. That motion, the court will grant that application. Counsel, I'll hear from you.
The state echoes defense counsel's silence.
Mr. Debonis, anything you would like to say, sir?
No.
Very well.
Just one, I have a brace on my leg. Is that all right if I keep it on there? So I won't be able to walk
So that's up to the department, the Union County Jail, the sheriff will advise them of that. I will also advise the lieutenant, but I don't have jurisdiction over the jail,
Okay.
so I can't tell you what you're permitted to have and what you're not,
Gotcha.
okay?
Thank you.
Sure.
Thank you, Your Honor.
Anything else you'd like to say?
I'm good.
I'm going to impose the mandatory fines of $50, $50 VCCB, a $75 safe neighborhood fund fee, and a $30 police fund fee. I'm going to dismiss counts 1, 3, 4 of indictment 17-09166. And consistent with the plea, I'm going to remand Mr. Debonis to the Department of Corrections for a period of 5 years with a period of 2 years of parole ineligibility. Is there an executed appellate rights form for this?
There is, Your Honor. May I approach?
Sure.
Thank you, Judge.
I have an executed appellate rights form, sir. In summary, while the court sentenced you consistent with the plea, you have an absolute right to appeal. You've got 45 days to file a notice of appeal. You're entitled to a 30-day extension of time, subject to the approval of the appellate division. If you can't afford a lawyer for purposes of appeal, the public defender's office will represent you, and you've got 5 years from today's date for a petition for post-conviction relief. Mr. Debonis, have you understood everything, sir?
Yes, sir.
Do you have any questions of me?
No, sir.
Are you satisfied with the legal representation?
Yes, sir.
I wish you well.
Thank you, Judge. Oh.
Mr. Ramos, take good care.